The Director of Public Prosecutions, Paula Llewellyn, says her office is prepared to formally request that notwithstanding the gun charge laid against the former MP for Western St. Mary, JOLYAN Silvera, the matter should be heard in open court. Gun offences tried under the Gun Court Act are usually heard in private. The matter of public access to the Silvera case came to the fore last Thursday after the media was barred from covering the hearing. The former lawmaker is charged with murdering his wife Melissa. He is also charged with using a firearm to commit a felony. The judiciary has since clarified that the decision was taken as one of the counts on the indictment was Silvera being charged under the Gun Court Act. That revelation raised the specter of whether the entire trial would be held in private. The DPP says her office is prepared to challenge that possibility.
Or at the appropriate time, depending on the circumstances, to still engage the court and make submissions that in light of the material, in light of the fact that this is allegations coming from a domestic scenario, in light of the fact that the accused is someone who held very high public office, and given the nature of the type of office, and given the nature of the public interest, that notwithstanding the provisions of the Gun Court Act, the interest of justice and the public interest would weigh heavier in moving the court to ultimately still exercise a discretion, but just simply enjoin the media, as the Chief Justice did in the Klansman cases.
The Gun Court Act, passed in 1974 by the Michael Manley administration, permits the court to restrict access to the trials of those facing firearm-related charges. But the DPP says her office must do a balancing act to ensure the public interest is protected.
The judge of any court is the final arbiter of its processes, and although the whole concept of the public interest is usually more weighted in favor of the DPP protecting the public interest as opposed to the court, and I say that without fear of contradiction, because we know what is on the ground. The judge cannot sit on the bench and know what is the state of our witnesses or what it is that we are dealing with in the trenches. And in this matter, certainly, we did not make any sort of issue. We would not have contradicted, the approach if the judge had decided in the public interest, notwithstanding the provisions of the Gun Court Act, to have the media there.
Silvera's next court appearance is scheduled for the 8th of February.